5 common types of wills in New York. When it comes to estate planning, understanding the different types of wills available in New York is essential. A will is a powerful legal tool that ensures your wishes are respected after your passing, protecting your loved ones and assets. Without a valid will, your estate could end up in intestate probate, where the court distributes your assets based on state laws, potentially disregarding your intentions. An experienced attorney can help you determine which type of will best suits your situation and ensure your loved ones are taken care of according to your wishes. The law on different types of wills in New York. New York law recognizes several types of wills, each serving different purposes. The most commonly used wills include simple wills, pour-over wills, and reciprocal wills. Simple wills allow you to designate who will inherit your assets and appoint guardians for minor children. They are straightforward but must meet New York's legal requirements to be valid. Pour-over wills work alongside living trusts. If assets weren't transferred to the trust during your lifetime, this will ensure they automatically pass to the trust upon your death. Then, the trustee distributes the property according to the trust's terms. Reciprocal wills are used by two people, usually spouses, who want their wills to mirror each other. These wills often specify that if one spouse dies, the estate will go to the other. It's crucial to work with a knowledgeable lawyer to make sure your will meets legal standards and accurately reflects your intentions. 5 types of wills in New York. Simple will. This is the most common type of will. It allows you to decide how your assets will be distributed and who will act as a guardian for any minor children. While it may seem straightforward, it's advisable to have a lawyer review your will to ensure it complies with New York law and avoids unnecessary legal challenges. Pour-over will. This type of will is used in conjunction with a living trust. Any assets not already placed in the trust during your lifetime will pour over into it upon your death. It's a way to ensure your estate plan remains cohesive and avoids unnecessary probate processes. Reciprocal or joint wills. Reciprocal wills are 2 separate wills that mirror each other. They're typically used by spouses to ensure that each partner's estate will pass to the other. Joint wills, on the other hand, are a single document signed by 2 people, generally with similar terms. However, joint wills are more restrictive, as they are harder to change after one person dies. Holographic will. A holographic will is handwritten by the testator and typically isn't recognized by New York's surrogate's court. However, if made during an armed conflict by military personnel or a mariner at sea, it may be considered valid. Nuncupative will. This is an oral will made in the presence of at least 2 witnesses. While this type of will is generally not valid in New York, there's an exception for members of the armed forces or mariners at sea. In most cases, wills must be in writing to be legally recognized. The process of creating a will. Creating a valid will in New York involves several key steps. First, the testator must be at least 18 years old and mentally capable of making decisions. The will must be signed in the presence of 2 adult witnesses who are not beneficiaries. Appointing an executor is another critical component. The executor ensures that your estate is managed according to your wishes, including paying off debts, distributing assets, and handling any legal matters. It's essential to choose someone you trust to act as your executor and to consider appointing a backup executor in case your first choice is unable to serve. Guardianship for dependents should be clearly outlined in the will. This is particularly important for minor children, elderly parents, or family members with special needs. You may also want to name guardians for any pets. Ensuring that your dependents are cared for can prevent potential disputes or confusion. Lastly, the disposition of assets is a fundamental part of any will. It's important to specify how both monetary and sentimental assets should be divided among your beneficiaries. Your attorney can guide you through the process of creating a comprehensive estate plan that includes a will, trusts, and other necessary documents. Protect your legacy and your loved ones by creating a well-structured will. Reach out to Schlessel Law at 516-574-9630 or visit us at 34 Willis Avenue, Suite 300, Mineola, New York, 11501. Our law firm is dedicated to providing personalized estate planning services that meet your needs and ensure your wishes are honored.